Hello, I'm Maritime Attorney Tim Young. In this video, I want to discuss with you the 5 keys to winning your maritime injury case. I want to discuss with you the 5 ways that your company is going to fight your case. Also, at the end of the video, I'm going to discuss with you when you should file suit as soon as possible, as well as when you may not even need a maritime attorney to help you with your claim. Our office here in New Orleans has been helping injured maritime workers for almost 20 years. We've been fighting for their rights. We've taken on most of the companies out in the Gulf of Mexico, and we know the tricks that they use when they're trying to fight your claim. Call us if you have any questions about your rights, choices, or options under maritime law or the Jones Act. I hope you enjoy this quick video, and I hope you learn a lot about maritime law and the Jones Act. One of the first ways that your company tries to fight your Jones Act maritime injury case is by controlling your medical treatment. Under maritime law, you are absolutely allowed the right to choose your own choice of treating physician. However, most companies will not tell you this, and some companies even lie to you and tell you that they are allowed to pick your treating doctors. Usually this will come up when the company arranges for medical treatment for you, and sometimes they even ask you to drive 50 or 100 or 200 miles to get medical treatment from a doctor that they select. This is absolutely not required under the law. The law states that you are allowed to choose your choice of treating physician. We always recommend to our clients that they insist that the company provide treatment from a doctor that our clients pick, not the company. The doctor that treats you is very important to your case. The doctor that treats you is ultimately going to decide whether or not you should go back to work, and that doctor, most importantly, will be recommending further testing or not recommending further testing to further decide if you have any type of an injury. With a lot of company doctors, the problem we see is that they are not willing to perform basic medical testing, such as an MRI or an EMG or nerve testing. We always recommend to our clients that they want their doctor that they choose to recommend and perform as many medical tests as possible, even if it's just to rule out some type of a medical problem. A basic MRI or nerve testing can usually tell if you have any type of a serious back or neck or knee or ankle injury. We always recommend at a minimum that MRIs be done on a back or neck injury to see if there's anything serious going on with your injury. So the first thing you want to remember is you always want to select your choice of treating physician. If your company is forcing you to go see doctors that they're picking, and sometimes they're even getting second and third opinions, that's usually a red flag. You want to watch out for that when you have a maritime injury case. A second common way that companies will fight your maritime injury case is by taking a tape-recorded statement from you. Now, I want to talk with you for a few minutes about why a tape-recorded statement often hurts or even ruins your claim. In a tape-recorded statement, the company is going to ask you a lot of questions. They're not just going to limit their questions to how did the accident occur and what type of injury do you have. Usually companies are going to ask you, did we do anything wrong that caused your accident? Did any of your co-employees do anything wrong? Do you blame us for the accident? Usually they're going to ask you questions like that go to the heart of whether or not the company is at fault for your injury. The second thing is usually companies ask you a whole lot about previous medical treatment that you may have received. What they're going to want to find out is, did you ever hurt that part of your body previously? Did you ever have the same type of an injury years ago that maybe you didn't tell them about? If you're not ready for these questions, a lot of times when you give your recorded statement, it can ruin your case. I'm going to tell you, under the law, you absolutely do not have to give a tape-recorded statement. If you choose to give a tape-recorded statement, it's very, very important that you discuss with the company if they did anything wrong or not, and you want to actually tell them what they did wrong or what co-employees did wrong. Your statement can be used in court against you. It's like they say on TV, anything you say can and will be held against you. If you're going to give a tape-recorded statement, we recommend that you do not discuss the facts of the accident as far as blaming people. A real good thing to tell your company is that you would rather not point the finger at anyone or discuss who did what wrong that caused your accident. You can simply say during the recording you don't want to get anyone in trouble, and the fact is that you had an accident, you had an injury, and that's all your company needs to know at that point. Another thing we recommend is that if you do choose to give a statement, you want to be very honest about everything. You may think it doesn't make a difference if you hurt your back years ago and it never amounted to anything, so there's no point in telling the company. The company is going to go look into all your prior medical records. If you give a recorded statement and you say that you never hurt the same part of your body in the past, they absolutely will deny medical treatment to you. They will use that against you if you ever file any type of claim. So two things. First, we recommend that you do not give a tape-recorded statement. That's the best thing to do. That's the best approach. Simply say, you have information about my accident. You know it happened. They may have written reports already about your accident. When a company's trying to take a statement from you, it's only going to help their case and not yours. So the first big idea overall is that you should not give a tape-recorded statement. If you choose to give a tape-recorded statement, we recommend that you only answer questions that you're comfortable answering. You can tell your company very politely on the statement that you'd rather not answer questions about who did what wrong. You may not have thought this through all the way when they ask you those questions, and it's not a good idea to simply play the good guy and say, no one did anything wrong, it's just my fault. That can come back to haunt you later on if your injury is a lot more serious than you think. The second issue, too, is if you do choose to give a statement, absolutely be honest about everything. It may cause some short-term problems, but if you end up in court against the company and you have to face your statement again, you want it to be an honest statement that you can deal with in front of a judge or a jury. So the second way the company fights your case is by taking a tape-recorded statement from you. Now, the third way that your company fights your case is by taking videotape surveillance of you. And what happens a lot of times is your company actually knows where you're going to be going during the first few months after your accident. If you think about it, your company is very often arranging medical treatment for you. They know if you're going to physical therapy. They know your routine. So this is a prime time when a lot of companies will send out video investigators to try to videotape you. You want to be very careful during the first few months following your accident that your company is not trying to videotape you. I want to talk for a few minutes now about why videotape can be so damaging to your case. A lot of times it's not the videotape that shows you doing anything very heavy or lifting weight that you shouldn't be lifting. A lot of times the reason videotape hurts your case is because it shows you doing something that's not consistent with what you're telling doctors. And I'll give you a few examples of this. A lot of times a doctor will tell a client to use a cane or to somehow use assistance when they're walking while they're getting treatment for their injury. If a videotape shows that you're not using your cane, this can sometimes hurt your case. It's really not a big issue, but it just shows that you're not following your doctor's orders as best that you could. Again, you're not picking up anything heavy, you're not doing any type of heavy work, but the problem is that there's a little inconsistency with what you're telling doctors and with what doctors are telling you to do compared to what shows up on the videotape. A second big way that videotape hurts your case is when it shows you doing something that you're denying to the company. And again, a lot of times these are not big issues overall, but the fact that they're inconsistent on the videotape is what hurts your case. I'll give you an example of this. A lot of times people will go out and find small jobs to do just to make extra money because they're not getting paid a whole lot by their company. The company then goes out and videotapes the person working at a car wash or working at a convenience store, and the company will then ask that injured employee, are you doing any other work? When the employee's faced with that question and they don't think about it, a lot of times they'll say, no, I'm not, because they fear that they're not supposed to be working or something. Well, the problem then is the company has videotape of you doing some sort of small job to make extra money, and you've now told the company that you're not doing that type of work. Again, this has nothing to do with the big overall picture as to whether you have a serious injury and whether that's your company's fault. The problem is the videotape now becomes very important when you go into court because it paints you as someone who's not being fully honest and not being consistent with your treatment. Videotape is very tricky. What you need to count on is that most companies are going to try to get videotape on you. You want to understand that a company is pretty much going to be wanting to know what you're doing. They're going to most likely be following you during the first few months after a serious injury. This doesn't mean you should panic. It just means you should be aware of it, and you should follow through and be consistent with what doctors are telling you to do and with what you're telling the company you're actually doing. The fourth way that your company may try to fight your maritime injury case or your Jones Act case is by controlling the money that you live on month to month. And this is a real important issue for a lot of our clients when they come to see us. When serious injuries occur offshore, usually workers are losing a whole lot of money because offshore jobs are typically very good paying jobs. Under maritime law, a lot of companies will only pay $15 or $20 a day in what they call maintenance. The company then gives the employee what they're calling advances each month to help pay their monthly expenses. Now, the problem comes up, and this is when companies get tricky, the problem comes up when the employee asks, should they apply for short-term disability? A lot of the high-paying jobs offshore will provide disability policies to these employees. The employee then has a maritime injury, and the company steps in and says, we're going to pay you maintenance, but we're also going to be really good guys and we're going to pay you extra advances so you can live on those and pay your monthly bills. Now, what's happening is the company is really controlling your monthly income each month. This puts you in a scary position. We know this. People come to see us and they're worried about this. What you need to understand is you absolutely should apply for short-term disability and long-term disability if you have those policies. Your company, and we see this a lot, your company may actually tell you, do not apply for that. Sometimes your company will delay sending you the policies and sending you the applications. Sometimes they tell you that you're not qualified for it, even though they don't know that, and they don't make that decision. Your disability insurance company does. The reason your company discourages you from applying for short-term or long-term disability is typically because they want to control your monthly income. That puts you at a disadvantage, and it gives them an advantage when they're trying to control your case. The last way that your company tries to fight your case is usually by rushing you back to work as soon as they can. And I talked earlier about how the company tries to choose your medical treatment for you. The company tries to pick a doctor to treat you. Well, hand in hand with that idea goes the fact that the company wants you to get back to work with them as quick as they possibly can send you back to work. So that's why when I mentioned earlier it's very important you choose your own doctor. You need to understand that the company's ultimate goal is to get you back out on the rig or on the boat as quick as they can. The reason they're doing this is because maritime cases usually involve a tremendous amount of lost future wages if the employee has a serious injury. The real goal of your company after you have some type of a maritime injury is to get you back out there earning what you used to earn before your accident. Usually lost wages make up the majority of a serious maritime injury case. So your company's goal again is to pick the doctor that treats you. They can then communicate with the doctor. Sometimes they're doing this behind your back. And they can then get that doctor to release you back to work as quick as he can so that you can go back out there and keep making the same amount of money you used to make. Now I want to talk to you for a second about what a lot of callers into our office ask. What they'll ask is, you know, my company has told me I can go back to work. The doctor's released me and he's saying, try to go back out there and see how you do. The only concern we have about that is once you get back out there, the company is controlling your environment. They control where you're working, they're controlling what you're doing. A lot of times companies will basically put up with an injured employee on the boat or on the rig, and they'll sort of avoid them and they'll give them light duty, and they'll do this for 2 or 3 months so that they can keep paying that employee the same amount that they were making before the accident. This employee is not doing themselves any type of a favor when they do this. They're actually hurting their case. We see all the time companies use it against an employee who goes back to work after an injury. It's unfortunate. It's not the way the system should work. People should be encouraged to go back to work and not have to fear that it's going to be used against them. But I will tell you absolutely, after fighting for maritime workers for almost 20 years, absolutely, when you go back to work after your accident, your company will usually use that against you when you end up in court. They will have witnesses come in that say that you were doing fine, that you weren't making any complaints. They will have people come in usually and say that you were able to do all the physical work that you were assigned. A lot of times the medic may give you treatment, but they won't document that. So when you come into court later on and say you were struggling and you were having a hard time when you tried to go back to work, the company paints that as being false and the company paints you as being a liar. Going back to the first issue I discussed in this video about picking your own doctor, Hopefully now you can see why that is so important. What we always tell people is make sure before you try to go back to work, make sure you've picked a doctor that you trust. That's the first most important thing. Make sure that you've had any type of medical testing done that that doctor can think would possibly help you. Usually this involves MRIs, sometimes it involves nerve testing, and the reason for this is a doctor may see something on an MRI and decide that it's not a good idea to send you back out to work. You want to know that before you go back out there. You want the doctor to have a good, clear picture about any possible injuries you may have before he starts releasing you. A lot of company doctors won't do this for you. A lot of company doctors just give you therapy and they feel like maybe you should be doing better than you say you are, so they then release you to go back out and try to see if you can do the work. That's usually a red flag. Call us if you have any questions at all about being released too early for your work, or if the company's refusing to allow you to pick your doctor. These are very important issues. Usually those two issues alone can really determine the value of your case and whether or not you can be successful in court later on. Now, I've just talked to you about the 5 main ways that a company typically fights your Maritime or Jones Act case. What I want to tell you now, like I mentioned at the beginning of this video, I want to tell you why filing suit early in your case may be very, very important. Hopefully you understand now, since we've talked about choosing your own doctor, we've talked about not giving a tape-recorded statement, we've talked about videotape that the company may try to get on you, we've also talked about how the company may rush you back to work too early. Hopefully you understand now that all of these items have to do with the company controlling your case. A lot of people will call into our office and tell us about bad situations that they've gotten themselves into months after an injury because the companies continued to control their case all during that time. The reason you may want to run to court as quick as you can and file suit is because you will be controlling your case from that point forward. Until you actually file your suit in court, you really can't make your company do anything. You cannot make your company pay for a doctor that you choose. You can't find out whether your company's videotaping you or not. You can't make your company pay for medical treatment that your doctor may recommend. All of these items you're restricted from doing until you get into a courtroom that puts you on even ground with the company. One of the most powerful things you can do after your accident is filing suit against your company. It doesn't mean you should do it in all situations, but once you do go into court and you file that suit, you then have a judge who's going to make determinations in your case. You can file motions in that case. You can get your company to do things under the law that they might not voluntarily do for you. You also get the process started. Usually it's going to take at least 6 months, sometimes a year or more, to move your case forward through the court system. The sooner you file your case, a lot of times the sooner you can get your case resolved. So we do recommend for serious injuries when the company's at fault, we recommend filing suit right away. The likely odds are you're not going to be going back to work with that company. You need to understand that. You need to accept that as soon as you can. The minute you accept that, you understand then that getting into court, getting a judge involved in your case, getting that powerful suit filed so that you can take action against the company and make them do what they're supposed to do under the law, you understand how important that is to your case once you come to the conclusion that your future is not going to be with your company. The final thing I want to talk to you about on this video is situations when you may not even need a Maritime or a Jones Act lawyer. That's right, I'm actually going to tell you when you probably don't need a lawyer for your case. And this is what we tell callers all the time who phone into our office. We get a lot of calls every month from people who have minor injuries. The company may be at fault for these injuries, but it really looks like that employee is going to be back working and they won't have any long-term restrictions on them because of the accident or injury. For those employees, we absolutely tell them, in our opinion, we recommend that they do not file suit or take any action against their company. I could give you dozens of examples where employees unfortunately didn't get a month or 2 or 3 months of wages while they were getting medical treatment, but at the end of the treatment they were okay to go back to work. They went to a local doctor that they trusted. Fortunately, all the test results were normal for them, and after 2 or 3 months they physically were fine and able to go back to work. A lot of times these people are upset because they did not get paid their full wages during these 2 or 3 months. We absolutely tell these people, do not file a suit over that. It is not worth filing a suit for 2 or 3 months of wages. A lot of times you may not need a maritime injury lawyer for a case like that. We personally do not take those cases. What we tell people, and this is sort of our standard on how we tell them to determine if they need a lawyer or not. If you have an injury that you think is going to prevent you from going back to work for any long period of time, 6 months or a year or 2 years or more, certainly if it's a permanent type injury, and the company's at fault, again, if you have an injury that's going to last more than a few months and the company's at fault for your accident, we absolutely recommend getting a maritime attorney involved. In situations like that, you need to control your medical treatment. You need to pick the right doctors who are going to treat you and do any tests they can to rule out injuries. You really want to be sure at that point that it's not going to turn into something very, very major and you're going to end up with a bad result because you let the company control everything. So call us if you have any questions at all about whether you're in a situation where you may need an attorney or whether you may not need an attorney, in our opinion. I really hope that this video has been helpful for you. I really hope that this has brought up some issues for you to think about. And if any of these issues apply to your situation right now, feel free to call us. The call is absolutely confidential. We really enjoy working with maritime workers. We love this type of work. We've done it for almost 20 years. Maritime work makes up about 80% of our practice. We file Jones Act maritime cases on a regular basis. We understand the law. We want you to understand your rights and choices and options more than anything else. We may not be the right attorney for you, and that's fine. You may not even need an attorney, and that's also fine. What we want to see, though, is that you understand your situation. You understand your rights. We want you to know your options, and then you can decide which way to go with your case. One final thought I want to leave you with. You can get a whole lot of information at our website, which is www.jonesactlaw.com. That's jonesactlaw.com. There you're going to find videos, you're going to find articles, you'll find frequently asked questions, and our answers to those questions. You can also call us at any time to discuss your rights, choices, or options. We really do want you to understand your options. I hope this video has been helpful. I hope it gives you a little bit more information than you had before you started watching the video.